Like you, we have many questions about Alabama's simplified seller's use tax. You know, SSUT. So we thought we'd ask a national expert. Martin Eisenstein is a senior partner in the law firm of Brann Issacson. He was part of the litigation team in the South Dakota versus Wayfair litigation that resulted in the U.S. Supreme Court clearing the way for states like Alabama to collect use tax on internet purchases. He spent the last 35 years of his career representing internet companies in litigation over attempts to collect use taxes. So we sat down with Mr. Eisenstein to discuss Alabama's SSUT program, something he calls a trophy piece of model legislation.
It's a trophy piece for model legislation. It was a mess. The state of Alabama's sales and use tax system was a mess. 450 counties, 450 municipalities, 67 counties, I think I have that right. Each of the municipalities with their own tax system, exemptions, et cetera. So an internet retailer, the companies that I represent, was forced to try to deal with collection of tax, not only at the state level, but in each of the individual municipalities. And that is and was a challenge, even for companies as sophisticated as some of my clients, Newegg, Wayfair, Overstock. These are sophisticated companies with sophisticated software. But when you think about the world that we live in now, if you went on the internet, right, and ordered something and waited 2 minutes for the company to try and check what the local sales tax rate is, do you think you would stay on that call? You probably would say, enough is enough, and we're going to move on. So that when Alabama adopted a system where it's one rate, one administration, that was a great feat and a great accomplishment and should be recommended and commended.
So, a simple question. From your perspective, is the simplified seller's use tax in Alabama constitutional?
Well, I'm an expert on the U.S. Constitution, not on the Alabama Constitution.
Oh, we're not getting in Alabama's Constitution.
But absolutely, I would never recommend a challenge to that. If I were asked by a company, do I have to really collect? Should I be collecting the simplified seller's use tax? I would say, by all means, you should. It's simple, et cetera. So there's a case called Wayfair that Sonny alluded to. I was involved in. I've been involved in all the major U.S. Supreme Court cases. And unlike the headlines in some news articles that we've read about, the Wayfair case didn't do away with the constitutional standard. It just said, we're going to take away an archaic concept for the modern times and say, you still need to measure a state tax on two fundamental principles. Principle one is, does it present an undue burden? Is it burdensome for the company to collect? You can't expect a company to do business across state lines and have to be burdened unduly. Obviously, they should have some costs and expense of doing that. The second principle is that it shouldn't discriminate against interstate commerce. And both of those are still cardinal principles. So when I look at the SSUT, I measure it from the looking glass of, does it raise an undue burden, number one, and number two, does it discriminate? A, it doesn't discriminate because the rates are no greater than the combined sales state and local rate, and even if they are in the unincorporated association, their SSUT has a provision whereby a seller could, a purchaser can get refunded the difference between the 8% and whatever their combined tax rate is. So in terms of undue burden, it's simple as can be. A seller applies to the Department of Revenue, gets approved, and files a form with the Department of Revenue showing tax at the rate of 8%. I can contrast that with other jurisdictions. I won't do that now, but to answer the question, I do not see any constitutional issues with the SSUT.